Good morning, sir. Are you Aleem St. Clair?
Yes, ma'am.
Are you sick?
A little bit, ma'am.
What's wrong with you?
Had a little fever.
When?
Like 2 days ago.
Okay. Like you're, all right. So, Mr. St. Clair, in cause number 23, DCCR 1390, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2023. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 23, 2117, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand that as well?
Yes, ma'am.
And then in cause number 23, 2044, you're charged with the first-degree felony offense of aggravated robbery from August 15th of 2023. Again, that has the same punishment range if you're found guilty, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 23, 2043, you're charged with unauthorized use of a vehicle, which is a state jail felony offense. And that is from July 11th of 2023. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have here on the computer some plea bargain rejections that you have signed with Mr. West. That shows that the district attorney's office has made an offer. So is it, what's the?
It would be a 25-year cap in both of the aggravated robberies. We had offered or discussed to dismiss that aggravated assault based on a plea in those ag robberies, as well as the UUMB. We rejected that. We went ahead and did a rejection of a 20 cap in the aggravated assault, but it was my original position to dismiss.
The courtroom shifts when the prosecutor mentions the plea offer. St. Clair was given a 25-year cap if he pled guilty to the robberies, and in return, other charges would be dismissed. But he rejected that deal. The judge looks up from her computer. You can sense disbelief. 25 years is long, but it's certain. Now, he's rolling the dice for potentially life.
So, Mr. St. Clair, I want to make sure you understand. It looks like what you have signed with Mr. West shows that the state's offer was for you to, if you wanted to enter a plea of guilty to the aggravated robberies, for a cap of 25 years, which means you would be leaving your punishment up to me. I could sentence you to 25. I could sentence you to less. It would depend on the information that was brought to me at a sentencing hearing. And the agreement would have been to dismiss the unauthorized use case, as well as that aggravated assault case, as well as some misdemeanors. If you go forward with trial on these cases, we'll go depending on how this all goes, because the offense dates from the aggravated robberies and they're to the same dates, but then that aggravated assault and the unauthorized use are from a different date. And what that means is that if you're convicted on those cases and sentenced by a jury, I could then stack those punishments on top of each other. And I don't know if I would do that or not. It would depend on the information that I saw during those trials. Do you understand?
Yes, ma'am.
Do you want to reject those offers and have all 4 of your cases set for trial?
Yes, ma'am. I'm trying to get a lower offer.
Pull that down a little bit.
I said I'm trying to get a lower offer.
So here's the thing, we're not negotiating anymore, okay? The offer, Ms. Malfino just stated that the offer is what the offer is, and unless there is some new information that is received after today, I will not accept this offer after today. So today's the day to either accept this offer, or your cases will go to trial, or it will be to some offer that's different hire or to me open unless there is some, again, new information that no one knows about. And is there any reason to think there would be any new information?
No, Judge, and what my position was in offering the cap that Mr. West and I discussed was to allow Mr. St. Clair to ask the court for probation.
The prosecutor calmly adds, "Now that he's rejected this, I'll ask that sentences run consecutively." That means if he's convicted, his time could stack minus 25 plus 25 plus 2, and so on. One decision just turned from risky to dangerous. Would you take a 25-year plea or gamble for a chance at 0, knowing it could cost you everything?
So you understand, if you plead to a cap, I can do, again, anything from probation up to 25 years in prison. I know nothing about your cases at this point. So I don't want to give you some false sense of, yeah, plea open to me and you're going to get a probation. I don't know. You could plea open to, or cap at 25 and I could give you the 25. I could give you somewhere in between. I can consider probation. I just can't know those things but right now because I don't have any information. And if you did that, what would happen is if you wanted to enter a plea and take that deal, then we would reset your cases for sentencing. We would get a...
I ain't do this shit I did on nothing.
Well, if you didn't do it, that's what a jury's for. So we'll get them set for trial, okay? All right, go back with the bailiff. We'll get them set for trial.
Thank you.
Good morning, sir. Are you Chad Holland?
Yes, yes.
And Mr. Holland, Ms. Minaldi's here. I know she's visited with you this morning on behalf of Mr. Gertz. And are you fine going forward with your plea this morning with Ms. Minaldi?
Yes, sir.
Thank you. And will your client waive the formal reading of the indictment?
Yes, Judge.
The prosecutor elects to proceed on 2 counts, dropping the rest. It sounds procedural, but every dropped count represents a narrow escape. Then the judge reads the key charge, fraudulently securing a document by execution.
Proceed on counts 1 and 2. Count 1 is the offense that you're charged with, which is fraudulently securing a document by by execution, and that's from December 30th of 2023. Count 2 alleges you were previously convicted of burglary of a habitation March 15th of 2004. And how do you plead to that charge?
Yes,
And is that prior conviction true?
yes,
Did you enter your plea of guilty and true freely and voluntarily?
I do.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Minaldi?
Yes, I do.
And do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I do.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Holland is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulently securing documents by execution. Also find that prior offense true. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Minaldi or Mr. Gertz. Do you have your discovery certification?
She gave it to me, I'm sorry.
Okay. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Ms.
Your Honor,
Minaldi.
may I be excused?
Yes, ma'am.
Thank you.